Yeah, correct. Thanks, everybody. It is 5:41, a little late. At 4:30, we held a work session with the BOCC, them presenting their version of the planning document that we're about to overview, land use code, dated November 8th, 2023. Tonight, we are here to essentially go over our last work session to discuss those edits. You know, this things have been passed back and forth many times. As many of you know, and this is more for the public, that the BOCC has taken essentially the lead on the land use code. So really, we are just a recommending body as we kind of always have been. So tonight, we are to give a report back to the BOCC, whether to approve, deny, or approve with changes. That's really all we're tasked here to do. So we're going to keep it at the table and send it back to them. There's a speculative tentative date for a public hearing in January that the BOCC will hold, likely similar to the one last year, last February at a large venue, affording everyone an ample amount of time to speak and have conversation. So with that, I'll turn it over to staff just to give an overview of kind of where we've been, what we suggested to the BOCC, and what they decided to send back to us. And then we'll bring it back to the table.
Pull your mic a little bit closer, John.
Sure.
All right, so from the last handoff, there were several changes to 2B. Many of the PC recommendations and edits were not accepted. AD 2.5 and residential 1 were separated as recommended, but the PQP column was removed. A few changes were accepted, but the BOCC did not agree with making so many uses conditional. They prefer to retain more its administrative review. Many of the PC recommended edits were accepted. Chapter 14, section 2, we amended density, subsection B as recommended by the PC, but they did retain subsection B about density. They accepted amendments to the ADU, but retained the threshold based on not exceeding the primary residence. They did not change to the 1,000 square feet. They retained the language for cisterns, but did not delete as recommended by the PC. As we know from our earlier discussion, there's cisterns and hauled water is still up for debate. The BOCC retained the definition of commercial, but they did not amend as recommended by the PC as it's related to table 2B specifically. We had the county attorney opined on chapter 13. No changes were made based upon the PC recommendations. And from chapter 1, section 3E was amended to remove language without a violation, but the transitional provisions remained. The BOCC added a change not considered by the PC, limitation on the lot size variances to A35 and A20 zones only was removed, and the remaining standards were retained. Those were all of the suggestions from the PC to the BOCC and where it's come back to the PC.
Okay, and for future considerations, you know, we're going to talk about zoning maps, legacy lots, stewardship areas, impact fees, considering separating rural, industrial, and commercial. But for now, we're tasked really with the edits in front of us. With that, I guess I'll bring it to the board. You know, we talked about cisterns and we talked about variances. Before that, Austin, was there anything else that the county commissioners wanted to talk to us about and that we were not able to in the hour that was afforded to us that you can recall?
Maybe the removal of the PQP column, but that was not anything that they were suggesting that we should.
Okay. And as Steve noted, it is still in 2A as a zone. though the commissioners removed it from 2B, so.
Right, so the 2A, I did not edit, table 2A yet. So the language is in red as it needs to be removed. Right now, it would be removed and, made that table 2A would match table 2B, which would need removing that section.
Or table 2B should reflect table 2A.
Right.
Which means adding PQP back and the urban growth area back.
The BOCC was recommending removing the PQP column altogether from 2A and 2B.
They just didn't make the edit.
But they didn't make the edit on 2A.
Correct.
Yeah, the problem with that is that, and TK just showed it tonight, we're gonna have properties out there that should be zone PQP. Whether or not the county has any role in land use over those properties, I don't think the real issue is that they are required, all properties in Dutch County are required to be zoned. Even public property, publicly owned property. I think that needs to be reflected on a zoning map. And that would imply that the table 2B have all those classifications, even though there may be a not applicable in terms of any sort of land use requirements. But that the maps themselves should be reflected.
The VLCC didn't really address with us earlier why they removed that column. Was there a major opposition to it, or they just didn't see it was important? Is there any attorney opinion on
My guess
that
would be,
issue?
Kate, that they saw it in large measure as federally owned or state-owned properties that they had no land use control over. So why even mention it in table 2B? But that's not all what the PQP was. PQP would apply to city sewer treatment plants, for example. It probably might even apply to a solar substation or a substation, of any sort, or a solar farm for that matter. Don't know.
And I would think if they're worried about, not having any say over that land, whether it's zoned to PQP, if it's gonna be zoned, it'd be better to be zoned to PQP than A5 that does say they have some say over what can happen in that zone.
Can I have a point of clarification? So there's some staff recommendations at the very beginning of this, which I don't need to read, but then there are some related actions: vacate resolution, vacate ordinance, update land use fee schedule. Are you asking us to decide those tonight? The related actions?
No.
Okay, I just wasn't clear. So all we're doing is looking at what your recommendations are.
Yeah.
Okay,
Which include all of those
Those are,
action items for them.
the board would be taking the actual action on those items.
okay, that's.
So our recommendation out of the PC would be
Move it to
to
them.
move it to the board to take
Okay,
action on those.
all right, I didn't, it's a little clear that this was,
Mhm.
okay, thank you. That made all sense.
So the three main topics I have from our work session with them, we have to go over cisterns, we have to go over the variance language, and it sounds like we have to make a decision on PQP. I guess let's just go around the room and just see how people are feeling around this whole process, what they want to bring to this, if they want edits. If you have something strong you want to add or delete, but we've been presented with what we've been presented with. I think I heard they may want some edits. Okay,
Yeah, I mean, I sort of feel like we're a little bit not useless right now, but there's not much to hash out, given how much we've given them and what they've come back to us with. I think we had some conversation about cisterns and variance stuff with them, and maybe it'd be good to come I don't know if we're gonna reach consensus, but come up with a little bit more specific direction for them tonight about those two issues. Other than that, I don't see a lot of place to really. I don't see their value in spending a lot of time elsewhere, because I think they've kind of basically made their decision on the larger philosophical parts of this document.
TK?
I agree with Kate. I think, I don't normally agree with Don on a lot of things, but Don was right. We could be talking about this for years. The devil's in the detail. This document reflects their interest, their concerns and their perspective. And we serve at the pleasure of them. We're appointed, we're not elected. So effectively, they're asking us to move this to a public forum so the public can view. It may not be perfect. I pointed out, I didn't ask for any changes. I just pointed out what I thought was a shortcoming with the zoning issue. It is what it is. If it's a problem over the years, then they'll make changes the next iteration. But for now, I think we did our best. I think we took all the questions politely. And I'm sorry when people feel they didn't get heard right up to everything. I didn't feel that way. I think that everything got submitted and could be changed even if it was in writing. That's not necessarily discussed. So I think we're faced with, deciding on the recommendation from the planning staff. Yes.
Yeah, I agree with all of what you said. I don't really foresee myself wanting to spend more time on this. I think as you do, it sort of hits, this 10,000 pound marshmallow. It's sunk without much response. And, we raised some issues tonight. I don't know if we made any headway, at this point. I'm not sure I care if we make headway. And, I think we just need to go on and pass it back to them.
David?
I guess I agree with these two gentlemen. I mean, they kind of, the commissioners acted like they want to talk about cisterns, but maybe we just kick it back and deal with it later. I think there's issues there.
Yeah, I'd like to look at that. Can we pull up this, page 94 in this draft code? Chapter 4. I just want to be crystal clear on this being in the county code versus, state statute on this.
There's
System,
a section and subsection.
section 4,
Chapters?
chapter 4, section 4.
Okay.
Should get us close, I guess. It's blatantly saying this in the, this county code. Basically, restricting wells, water, springs. Without like a water company's approval, is that a state statute restricting that, or is that this county code restricting that?
Chapter 4, Section 4, what letter?
D,
C,
3 and 4.
utility connections required.
So. From what I understood, this was a state statute deal. This isn't our deal, but right here kind of shows. This is a county code deal.
And what's you just want clarification?
I just want clarification that when I asked them, they're saying they're restricted by the state statute. But as far as I'm concerned, they're restricting it right here on the county code. I mean, is that a state statute deal?
Well stuff is state statute deal.
Yeah.
And it is
But-
within our code saying what kind of water you're allowed to use and is required to be there for you to develop.
But it's the the water districts. Huge, water, areas that they can't even supply that are restricting that, not the state statute. They're just, if that area is actually more realistic to what they can supply, then it doesn't restrict it through a state statute. It doesn't restrict me from growing a well if these water districts didn't have, such huge areas that they can't even provide water to, but they're restricting, and then we're falling back onto that, which you call, you get a well and they say, are you in this area? Yeah, but their nearest water line's 3 miles from me. Why is that water area so big, and who wants to fight them to bring their water area back down to what they can actually provide to the Delta County residents
But
versus
again,
what they want?
Marty, is that an issue in the land use code? I understand your
Does it not
your
say that
concern
right
with that,
here?
and that is real.
In the county code, right here, it says, doesn't it say it right here?
What's it say?
What does it say?
Read us what your concern is.
Well, that's what I was trying to pull it up on the.
Well, I'm reading.
I'm not sure we have the right place.
I'm reading-
Four,
I'm reading
C,
from-
3 and 4.
Yeah, right there, number three.
C3, special water district providers, isn't that what you're reading? If a subject property is located within the boundaries of a special district that provides water and or sewer service, is that what you're talking about?
That's
Subject
what I'm
property?
talking about.
Yeah,
I'm talking
but-
about who restricts them from just, who's making their water district, other than them.
Well, but not our land use code.
But we're reverting back to, we're letting these guys dictate what Delta County residents can get water or can't. Because they're, if you ask me if you want some concrete, I'll say, yeah, you want some concrete. If you ask them if you want to buy water from them, they'll say, yeah, you want to buy water. But Delta County residents should have the right, unless, if they can't even provide them, they should be able to drill a well or haul water and do that. That's what I'm saying.
So is your suggestion removing this? Not involving the districts at all? I'm trying to come up with a solution to your question.
My suggestion is finding somebody that's willing to fight for the residents versus just lay down and say,
Well, I don't understand, fight for the residents. We're here with the land use code.
Yeah.
What do we change in the land use
well, I was
code?
just talking to the Board of County Commissioners, so that's why I'm reverting back to this.
Well, I know.
Well, what do you want to change,
Is
Marty?
this a state statute?
I think 2.3 talked about a special district water provider.
No.
That's not just a water company. A special district is something that's created by state statute. And I think the voters have to approve it because they're being assessed. Every landowner there gets assessed to pay for the special district.
Yeah.
Now you're looking at special district water providers versus,
Yeah,
you
they're not a
know,
government
sewer
entity.
based water company.
That's like just a company.
They are.
It's
Yeah,
like-
they're different.
They are, if they're a special district, they
No,
are.
they're not, they're not.
They are.
Water lines out to bid.
They're a special district.
There's a difference between a special district water provider and different water company.
Keep reading number 4. All I'm saying is
Just
just,
go down to the.
the next one is.
Okay, that's what we're.
Well, again, I'm willing to look at it. I'm just not sure what
Other
you're
water
asking.
providers.
I agree with David. I don't think this is addressed towards water companies. Non-publicly or non.
All I want to say is, is the code, this code we're putting out restricting it, or is the state statute restricting it? Which one is it?
John, you know where we're at.
I guess state statute doing it, or is this code doing it?
So when you look at paragraph 3, the statutory reference there is just, it's 32-1-101 NC. Okay, that means that's the entirety of the Special District Act. Okay, so I don't know that whether that particular limitation is in there or not. I'm happy to look at that.
That's what I'm
Okay.
asking.
Okay, so I'm happy to look at that if you'd like me to. But yeah, David makes a very good point. The 3 is in regard to special districts, which is a whole different animal than probably most of the private water companies in Delta County.
Do we have any special?
Well, number 4 talks about water providers.
That's what I'm saying. Yeah, that's
the
the,
applied.
Yeah, but to that point, number 4 says can feasibly be served by water or water company. So there's a lot of leeway in that word feasibly. If you got 3 miles from the line, is it feasible to get water?
That's why I was asking.
It's also only in the growth management area.
You what?
This is only pertaining to in the growth management area, this other water providers. So if you're in the management area of Purpose Creek or Cedar Edge. But
Right,
the
so it
whole
doesn't
county,
Extend to the whole county,
no, it's not the whole county.
only in the GMAs. And those are probably smaller than the water districts, the water, where the water comes from. Generally, there's gonna be water in those.
I don't think this is more restrictive than the state statute. I don't think we're creating an issue here. Okay. Matt, how do you feel about what's going on here?
Well, there's certainly some consternation over this whole deal about cisterns and where a landowner is able to get their water from. It seems to me that the water provider companies around here are kind of holding the landowners hostage to what what their infrastructure will support. And we've also said in Delta County, it's a pay-as-you-go in development of utilities. Well, at what point do we say if we want growth to happen in our county, that we either come up with a grant or we come up with some way for those water companies to push those lines out to the individuals that need them? And if we can't get that point, then we should allow them to have a cistern and haul as much water as they can buy.
Or a well.
Or, yeah, or well, but I think that's beyond our,
The well is the state,
yes, that's
state
state.
issue.
I understand, but you call to get a well, the first question they ask you, I've done 10 of them in the last year. The first
Right,
question they ask, are
But
you in
the
a water
county
district?
doesn't have say over them.
So I think we recommended
That's what I'm clarifying.
canceling that whole
The county
section
doesn't have
about
to say
this,
that. You're
we?
saying it's a state deal.
To avoid a lot of this
Right.
consternation that we.
They wanted it back in, so I think.
Well, then they're gonna have to be the ones that answer the word feasible and hardship. And when they make a decision on each one of those steps, that now becomes a precedent for everybody else.
That's what I was saying.
So
You give one guy one, and then the next guy comes in, no, where do you go from there?
I'm all about giving the landowner as much leeway as possible to develop their land however they want to do it. So long as it doesn't pollute the surrounding neighbors in other areas, I'm okay with that. They want to put in a cistern, do it. You want to buy water, do it.
So Matt, should we remove the language that says we don't allow whole water, just take that out?
Yeah,
That's what I say.
I would say that.
Let me ask, let me add just that question, because I know this has come up and I honestly don't know if it's in this draft. There was notice purposes in regard to hauled water and that, this larger conversation. There was discussion at one time, and Carl, you might remember this, about if you're not hooked to a municipal supply or a reliable supply or whatever, that there's a plat note placed on the putting any future purchaser on notice that, hey, your water might have a questionable supply or something like that. Is that in, Carl, do you remember? I know that we had a discussion about that in some form, I don't know.
Relative to if there's a subdivision, then
If there's a subdivision,
then there are some standard notes and some special notes to be considered that can get into that.
so that could be,
It could be, and many of the older subdivisions prior to the land use code have language about restricting what you can actually, how many units you can have on a property or, and that's in place, that's recorded on that plat. So there are plat notes in effect.
but specifically about water, because I mean, I think,
Yes.
a lot of people know, the situation, down around Phoenix and that sort of thing, where you have whole communities that were hauling water and all of a sudden their water goes away, you have whole communities that don't have water. And that's what we're trying to prevent.
Understandable.
There is a certain,
That's a risk.
yeah, it is a risk, but what is the role of the county? In
No,
help notifying and creating a system to where people are on some sort of a notice, not completely buyer beware. But some sort of a balance there. I think that's the balance that I would think that the PC and the BOCC and the planning, the whole system is trying to reach. How much buyer beware on one side and complete control, there's gotta be balance there somewhere. Just a
And
thought.
I'd kind of asked that of the BOCC in that meeting was what is it gonna look like? Is every single one if everyone gets a cistern, are you gonna have to go through a variance?
No, it's gonna be the norm.
No.
Right.
That's not the case.
So if you meet the hardship. you
The way the cistern language was in the 2021 code was cisterns were prohibited for any residential use.
Right,
This was the attempt to say, well, there are cases where cisterns should be allowed. If you have a water source, you have a well or a spring, or, you have permission to use a certain amount of water, you can apply that through a system because not all the water sources have the water pressure. So the cistern helps create that condition. It also recognizes that there are gonna be places where there just is no ability to have water. And rather than saying that there's no development that can occur on that property, that you can still have a single family residence and an ADU with hauled water. Where the variance really comes more into play is if You have an existing situation, I have 3 units, they're all in hauled water, which was allowed prior to the land use code. That's allowed to continue, that this is saying, you can continue that, if you want to expand that, then you would need to come in for a variance.
Well, and then to John's point, how is it gonna be recorded then that we have these cisterns for these inadequate water supplies? Is that a land use thing, or is that just done at planning level of make sure you make a plat note? Is that an internal function? Or
We
is
don't
that-
know where all the cisterns are.
No, but going forward.
Going forward,
Yes.
if they come in through this process, yes, then we would know where the cisterns are. I don't, whether or not we keep record of it, we typically haven't.
Maybe who.
I mean, it's part, if somebody were to come in and it's part of the permit, it's part of that file, it's part of the record in that context.
We need a residential cistern zone. I'm just saying,
You map of.
identify for people, I understand what you're saying on the plat note, but I'm thinking of, if I'm a buyer from the outside, the only thing I get that may show me that would be my title report. And unless it's recorded and the title company picks it up, I would not know about that caution note or that buyer beware or whatever you want to call it, because it's on a plat. I would say most people don't look at the plats specifically before they close, or if they do, they get it in an 8x10, and you can't read it. And anyway, so in a PDF. So I'm just, I know I say facetiously, do we want a cistern zone? But technically, it would be the only way to identify everybody who's on a cistern.
But a plat note is constructive notice, and title companies probably should be picking that up. And I agree that a lot of title companies might not, but
Just like it shows you're in this water district, but it shows you're in that. You might not really be in that. You might, because the district's so huge, their water line might be 5
But
miles.
that
from there.
doesn't show up in your title report. And it doesn't,
Well,
that's,
you can get extra coverage to do that.
if you ask, but in other words, the water companies don't file something that goes onto a title report. It's just sort of, you have to know that you're in that water. If you ask about water, then you'll hear about it. I'm trying to figure out, how do we let the public know about what this potential problem is in the easiest way? Only thing that I know they get is look at the maps or the title report. John is saying by law, on the plat is effective notice. And legally, I know he's right, but I just don't know practically, that's gonna inform anybody.
Matt, did you have any,
Pardon me?
did you have anything else?
Yeah, I just want to say, back to the notification piece, unless we bold, big print, water is an issue in the western part of the US. Do your due diligence and find out if you have water.
Where do we say that? Where do we put that?
Put it on any, all the plats as a note.
Title.
Put it on the Delta County frequently asked questions page. I mean, that's the first thing people look for when they buy land. Do I have water? Do I have power? What do,
Yeah, but I'm beginning to think that people are gonna look at this code and say, I don't need it. I can haul it. And there's plenty of companies, let me say, there are a number of companies, that's all they do is.
Well, that's fine.
Legitimate
Person wants to
company.
pay for that, that's fine, in my mind.
Okay, so water may not be
But
the issue.
when that dries up, then,
Well, you're putting development in areas that it maybe shouldn't be because they don't have services. That's the problem.
Well, if in the places should be.
well, that we
easier,
think it
then-
shouldn't be.
Then naturally it would happen so hard, then it goes somewhere else. If it was the place to be, it happened. I've been through roadblocks, that's when it moves. That's how development works.
That's why you raise the roadblocks where you don't want to go.
Well, I'm not here to create roadblocks. I'm here, if they made it easier for people to use and get through, they would go there naturally. They don't, it's not that way, so that's why everybody's out here going.
We're gonna keep going around, Victoria.
Specifically on cisterns, or, so I have a few suggested edits to 2 different processes. So the first one would be when there is a violation identified, I would like to see some language in there about serving the property owner with the notice of violation. Specifically because if I own a property and I have a renter staying there and you're notifying my renter that there's a violation and they're not curing it, and this violation starts to accrue day by day charges, and the second side to this is the fee schedule for the code. If we don't have a fee schedule by next meeting.
Steve's, no phone calls when you're.
Yeah.
So if we don't have a fee schedule by next meeting, then effectively we're voting in fines that we don't even know what they are. So we might agree that something is a violation, but now we're voting in, yes, it's a violation, the fee is to be determined later. Without any input from us or the public on what that fee could be.
That's not true. The public will have, there's a public hearing, and they
No,
can
these are
change every.
separate resolution. So there's sections in chapter 6, actually section.
Chapter 6, because you didn't see this.
No, so the fee schedule for the entire code, we don't have.
No, that's not under our purview.
I know, so I'm saying if the fee schedule isn't presented to us, we're voting on a code saying, yes, we agree this is a violation that they should be fined for. However, we don't know how much the fine is and we're still agreeing that that's the case. I mean, I, for one, am not agreeing to that because if I don't know what we're fining them for, okay, so it's a violation that, your dog got loose. Yeah, we can agree that's a violation. How much is the fine for that? Is it $100 or is it $1,000? Because that makes a big difference on whether I'm going to vote yes or no. So I really would like to see that addressed before we take this to a vote is what are the fees for these violations?
Austin, you send a
Fee schedule,
draft fee schedule in your
yes,
packet?
he did.
Can you say the specific section you're referencing?
So the sections that are left open for separate resolutions are in chapter 6. And it's gonna be sections, let me find it. Section 2, 3, and 4. And they're all left blank for separate resolutions to be passed regarding road impact fees, fire fees. I can't remember what the third one is, but if you scroll to them.
Yeah, those aren't dog getting out. Those are like you're developing a property and we want you to pay for the fire district.
So I'm talking about two different ones here. I'm talking
Okay.
about chapter 6 has 3 different sections that are left blank, talking about fee schedules that I haven't seen. I missed.
These are impact fees, not fee schedule.
Steve, we're talking about impact fees.
So the impact fees.
They haven't implemented them.
We're talking about impact fees.
Go ahead.
Be voting on fees that we don't know what they are. We don't know what the fees are for the fire impact.
We don't.
And so my suggestion would be, if we don't even know if we're gonna have them, to remove those sections, that language, and to let that come about when it matters. If it's gonna be a thing, we can update and we can talk about what the fees should be for those separate things. But why are we holding 3 different sections for fees to be separately passed?
Because we don't know what they are.
Because we don't know what they are.
What's
Yeah.
in-
So why
We have a
is it
study underway.
here?
We have a study that's supposed to be underway.
And we're gonna codify those exact numbers within this code. Things should change if the
it's not
the
working.
list of things,
Double.
yeah, I mean, I think that the county should be able to update the fee schedule at a different pace than this land use code. So I think you can look at the draft fee schedule that Austin sent out to have a baseline of what you would agree to now. But regardless, it could change
And I think that,
after this is
And
adopted.
this clearly states the Board of County Commissioners are gonna be dealing with the fire impact fee, road impact fee, the open space fees. We don't have anything to do with it. So we've just left
A placeholder.
a note, because we've heard from the public and from the fire districts and from the public about impact fees, that they're important to everybody and we need to address them. So we're recognizing in the land use code that at some point they'll be addressed. It's up to the Board of County Commissioners to want to do it. I wouldn't want to take them out.
and so really my suggestion here is that maybe we could ask the Board of County Commissioners to provide us with a sample for these sections as well, so that we're not blindly voting on fire
did.
impact fees
Austin sent it,
for these as well.
yes. Within the documents that Austin sent is, the title of the document is 2024-01.10_BOCC_Rezo_ land use fee schedule update. That would be the fee schedule for 2024. Included in that are everything from a new address permit to fire mitigation fee of $500 per lot.
Yeah, public sites is 300 a lot, fire is 500 a lot.
Roads is to be established, and that was probably part of our discussion, was figuring out how to figure out what a road impact fee should be. Land use code.
So 2 of the 3 are,
Okay, I'm not seeing the,
Is it in the zip file?
it's in the zip file.
Yes.
It's in the zip.
And Victoria, just real quick, for clarity, am I wrong that the section you're speaking of is application related fees,
Mhm.
not violation related fees?
well, I was talking about both of them, because I didn't know that there was a fee schedule sent out. I don't see that on mine. I see now I'm seeing a fee schedule, for, it's just titled Exhibit A. I'm not seeing the one that you guys are referencing.
It sounds like this has been answered. There are fees to it. We can get you that information after. Do you want to talk
Okay.
about the other?
Yes, yes, I do have other suggestions.
Great.
So, again, bringing it back to the notification of the property owner.
And so which chapter section are we in now?
And so the first language that I see where it would be relevant is chapter 1, section 3E1.
Okay.
Not or first chapter 7.
Chapter 1, section 3. That's gonna be E1.
Subtitle effect on existing violations.
Yeah, so my suggested edit would be for A. If a violation occurred prior to the effective date and continued past the effective date, then the county may pursue appropriate remedies of the violation 30 days after the notice of violation was served upon the property owner.
Sounds reasonable.
Reading E1A, is that what you just read for?
She added her language within
She
there.
said what she thinks it should be.
Oh, I see.
Yeah,
Okay, I'm-
adding the 30 days.
Yeah, so state it again, if a violation occurred prior to the effective date, but continued past the effective date, the county may pursue appropriate remedies of the violation 30 days after the notice of violation was served upon the property owner. So that, this is just stating that they can't pursue remedies until they're absolutely sure that the property owner has been notified that there's a violation.
Is this like a proper serve, like a,
Yes, because like, to me, it just makes sense when the consequences are, fees that can end in foreclosure on your, or a lien on your property. You should be notified, and if you're renting this property out to people who are being careless and you have no clue, you could lose your property due to their carelessness. So, and right now, if I'm not incorrect, the procedure is just a mailing. I mean, that mailing, who knows if it's going to a PO box or if it's going to the renters throw it in the trash. You don't know that the property owner even did.
Letter to the landowner.
Can
John,
somebody answer
there,
that?
you have a notion about that?
where's our guy?
It means that there's some sort of response that has been received.
Right, if it's a renter, that renter's name doesn't show up on the property owner's name, they'll send it to the, to the tax lot. Yeah, I don't think it has, I don't think it has to do with the renters. You just wanna make sure that the owner is served properly, correct?
Yeah, for
Nothing-
something
nothing to
so
do with the
extravagant.
renter. If the owner of the property, which is based on the county records, if they're served properly,
And evidence that they've been served, a proper serving.
well, a registered letter would be evidence.
With
With the
response
signature.
required.
Well, yeah, they
response.
usually required, I mean, I've gotten them, they have to return mail
And
and.
so right now, there's no language in here indicating that that's the procedure. And I don't think that's how they've been done. So people therefore are not being notified of these violations until who knows when they find this letter or if it ever gets to
Do we
them.
know that to be true?
That's what I'm asking, but nobody's given me, is that the procedure? There's no language stating that.
Do we know that there's a problem? Have we heard that there's a problem?
Yeah, I've heard there's a problem. So,
Yeah, maybe
And that
Carl,
renters are getting notified.
maybe Carl or Austin can opine about how many violations have happened in the last 2 years. How many violations have been notified of the land use code?
Actual notice of violations, 0. All of them have been advisory letters. And per the enforcement processes in chapter 13, section 4, it speaks to the process is there's 30 days to do a field inspection. An advisory letter will be sent out. After an advisory letter, there's no determinate time. It depends on the severity of the violation. The code compliance officer has worked with people to the point where at this point, no notice of violations have gone out. If a notice of violation goes out, that is the formal notice, and that's where it would be, doesn't specify here to be certified mail. But that process is in chapter 13.
And so so I have some language for chapter 13 too, specifically around this, but the first time it actually shows up, in my view, is in chapter 1 where we're looking at.
But taking just that section isolated from the rest of the code is not really taking the whole code into consideration. It does talk about, how they're presenting notices and things like that. And I think we're talking about something, I mean, I think your recommendations have gone to the Board of County Commissioners. If they want to change it, they can change it with the council or whatever. I don't know that it's necessary for us to do tonight.
Did they change anything in chapter 13?
No.
And I'm not saying you're wrong, but I do think the whole code addresses that, and we haven't had any violation.
In chapter 13, does say notice of violation will be issued to the property owner or responsible party, not just to the resident of the property.
So in total, I think it covers what's supposed to happen.
And so,
Just that section that you read, E, A, in itself, it was read alone. I understand what your concerns are, but that's not everything that's involved with the violation.
and I know that like you said, there's a lot more language here that's all surrounds that. Like another concept that I like to bring forth to you guys is that where is it become our responsibility to go out and enforce these things? And where is it the property owner's responsibility to, like, civil suits? Those are a thing for a reason. If you have a problem with your neighbor, you take them to court if it's not a violation. So the concept here is that you would have the property owners, when they're submitting a complaint, because as it is right now, the staff here has no obligation to investigate anonymous complaints. The complaints have to be in writing. So I'd like to expand on
Complaints
that.
don't have to be in writing.
Don't they have to be?
They do. We will accept anything.
Well, in order to be investigated,
They just have to not be
language
anonymous.
in there, yeah.
Yeah, we got it.
Not anonymous. You'll accept the complaint, but there's no obligation of Delta County staff to investigate an anonymous complaint. That's the language. So I'd like to expand on that and say that Delta County staff doesn't have an obligation to investigate a complaint unless it's in writing and there's adequate proof of a violation. Because if you're on your property and you can't take a picture, you can't take a video, you can't provide any kind of proof that your neighbor is actually bothering you, why should we have our code enforcement officer go put himself in danger, lurking around the property, trying to find this violation without a picture, without a video, without any kind of proof that it even exists?
That's kind of what he does though, already.
Well, the neighbor people are not, Well, and then the other side of that is that what is a field inspection? There's no definition unless it was added to this update one. But there's no definition, and I think that we should have one. I think that field inspections should be done from the public right away. Or with prior approval from the complainant property. Because that's the person that it's bugging, so if they wanna go on their property and scout for this violation.
I'm gonna guess he doesn't go on it, but somebody's contacting the property owner or whoever's there and gets permission. I mean, I think that it's handled, but again, I feel like because you reference civil suits, as soon as you do that, you put these conversations into this legal framework that we as a planning commission can't deal with. I know you keep wanting to ask us, and we said, submit it to the county attorney. If there's legal language that's there and he approves it, I don't know that we would ever object to it. But you're asking us to do it without his approval, and that's why I think your grievance be heard before wasn't quite fair to the rest of the planning commission, because I do think you're asking legal questions, and I'm not saying they're wrong, but I don't think they're for us to
It's not a legal
determine.
question, I haven't asked a
Well, if
question.
it involves civil suits, like you said.
No, I
it does.
said, there's a procedure when you have a problem with your neighbor. It's called a civil suit. If it's not against the code, if it is against the code, we now have a code enforcement officer who can go handle that.
Mhm.
However, why are we paying someone to go out there and investigate something that may be frivolous? There may be no grounds to it. Can they at least provide grounds? As it is, it has to be, it can't be anonymous, so you're giving them some accountability to their complaint. But I just don't feel that there's any need for our staff to go investigate.
Yeah, just like I've done where I've spent $150,000 over that matter that you're talking about.
Sorry.
Okay.
So I have specific language that I just wanted to run by you guys, chapter 13, section 4B1.
Okay.
The code compliance officer will respond to the site within 30 days of receiving a valid complaint and complete a field inspection. A field inspection may be done from the public right of way or with prior received permission from the complainant's property. Nothing in this section shall be construed to constitute a right of Delta County staff to trespass.
At times, Delta County staff may get a court order
That
to
is not
investigate
trespassing.
them. And, so, correct, it's not trespassing. I mean, there's these other alternatives.
There are, and that's what I mean. There are other alternatives, and if it's a serious problem that needs to be, if it's a serious problem that is actually bothering a property owner, there should be some kind of evidence that they can provide that it's bothering them. I mean, you can't take a picture or video with a timestamp or anything to prove that there's an issue, if it's your neighbor or, you know.
This is where a judgment of the code enforcement officer comes in. I mean, there's a stepwise progression. It seems to me. That if a complaint is filed with name, meaning non-anonymously, that the code enforcement officer has to sort of figure out what I can do, what I can't do in investigating that claim and using their judgment to do that.
Yeah, I don't
So I
think
think
we
putting
put the onus on
conditions.
the complainant
Complaining to the guy.
to prove it. And the plant, you know, if he can't prove it and he still has a complaint, to know if it's a violation, I think it has to be treated seriously. So I think the bottom line is staff has to take all complaints, written or otherwise, in the same level, meaning they all get handled. And if they're not compliant, then there's a process that's gone through. If they're not even a violation, then the violation officer or the Everett would tell them that. I don't think, I think all the suggestions you're talking about, if the Board of County Commissioners wants to change it, I'm okay with that. I don't know that we need to do that tonight.
Does, who's getting complained about get to find out who's complaining? Or is that like, how's that go down?
Yeah, it's non-anonymous, it's public information.
Yeah,
Well,
well,
so they
if
can
if
find
there's a
out.
written form, it
You say,
is all, in all likelihood going to be the public record.
there you go. That's good.
So
Right.
my concern is that if we don't have any suggestions, if we don't discuss it, if we don't take a vote on these suggestions, they're not gonna look at them or consider them. Which if,
I would say they'd be offended by that. I think they'll look at them specifically. I can make a recommendation, I'll make a recommendation that we move all those recommendations forward because I'm not objecting to any of your recommendations. I don't know that we need to change it. I'll certainly support having those being reviewed by the Board of County Commissioners without our input, without our changing anything. I'm okay with that.
well, and see, I'd like to I have a lot of them and,
And
but
they've seen them all.
we're supposed to suggest them here so that you guys might see a different perspective. You know, my perspective is that we should not be paying someone to go check out something if there's no evidence that it's even there. If it's really bugging them, they'll have evidence, especially if the code
Victoria,
compliance-
what's a suspicion or a complaint about something that is not. You're not able to take a picture or a video of, there's
Like sound.
issues in here. Yeah,
You think someone in a basement?
The other part is, how do you define proofs?
Yeah.
Who makes a complaint that, and the person, the code enforcement officer has to, what is?
picture, video recording, I mean,
Say this happens now.
if there's nothing that they can provide that. I mean,
Well, if
if you
they're burning
can't see it,
cows, let's say they're incinerating cows.
That's illegal.
And then- well, maybe it's not inside, well,
Inside.
again. Legalistic.
you can't necessarily take a photo, you can't take a record.
you're creating well, and you can't see it or take a photo of it. Everett's supposed to enforce it. If he can't see it or take a photo of it, he's supposed to go on the property and find it. Do you think- That's the thing, because I'm trying to prevent that he won't have to go and investigate on a non-anonymous complaint without proof. So, and again, I feel like we're incentivizing this neighbor against neighbor type of, mindset when you're complaining about things that aren't directly affecting you. Your example with the well is a good example. But again, how is Everett supposed to go enforce that if he can't prove it without trespassing? If they have a well permit, then how are they illegally operating a well? You know, if there's any record of it, then it is permitted. So I just don't understand why it would be such a big deal for them to have to provide proof before all of our tax dollars go into action for, a Karen next door that doesn't like you.
That's gonna be an Everett's judgment about what's proof, what's not proof, what he needs to proceed, what he doesn't need to proceed. The thing that you're missing here is the complainant. You know, we have complainants all over the place on the blog that I read, partly your group does.
Oh, God.
I mean, the complaints about junk and debris and all of that are just so numerous. So let's not cut off the complaints. Let's not say we're gonna set up artificial boundaries for those complaints to come in. Leave it up to your staff to make a judgment about whether it's real or not, and they have to go through a process to do it. If there's not proof, there's not gonna be any action.
I feel like it puts an unnecessary strain on our.
I understand, I think you're very clear how you feel, but you haven't gotten any support. So I think it's important for you
The
to.
investigation.
Right, good point, that's how you find proof.
The function of the investigation is to find the proof, and in your scenario, you're asking neighbors to become private investigators rather than our staff member who will likely follow the law and not trespass, will collect information in the right way, will know where to look for the information to make the process as short and reasonable of a process as it can be. Versus requiring the neighbors to essentially spy on each other, to elicit help from their other neighbors, to hit against their neighbors.
Fly their own.
Yeah, I think having an impartial staff member that's responsible for investigating is better than putting the onus of proof finding on the citizen. And Everett, or whoever the code compliance officer is, if they get a complaint that just is totally wacko, it will probably be pretty easy for them to quickly find that there is no reasonable proof. But it doesn't mean that we shouldn't take those complaints.
I'm not hearing a ton of appetite for, we're here as planning commission to discuss planning. I know this is in our code. I personally don't feel comfortable discussing what the code compliance officer does, and I don't hear a lot of comfort from anyone else. With that, Tate, do you have any feelings on this? We've gone full circle here.
Yeah, my problem is still the table to be, because I think that's the definitive. Predictability that neighbors and landowners and purchasers. Get out of the whole code, and I still think there's bizarre inconsistencies, and I'm not gonna suggest edits because they've already. Decided that our edits are. Not in their interest, but for example, I think it's bizarre that. You can put a storage facility in any zone without any notice. And I think that offers. People who've been living in any zone, R5, R1. Lack of predictability with what their neighbor can do and come put in a large outdoor storage yard. So that's one of the inconsistencies. And I think that's. A lot of people who might not be relying on a storage yard going in next door. The other one that's bizarre, I'll just point out a couple. Resort conference center hotel in the A35 zone is conditional. In all other zones, it's noticed, but in the A20 zone, it's permitted as a limited use, no notice. So in the A20 zone, there's a large, often the many 5-acre properties, 10-acre properties. Why would it need to be conditional in A35 and not in A20? So I don't think the table's done, but I don't have any specific edits to put forward, so I won't be able to, if we're voting to. Approve this in some manner or bless it, I won't be able to do that. That's it.
Okay. We've gone around the room. Sounds like we're not on the same page with cisterns or variances or code enforcement. I was out of order. I did hear a motion from TK at a certain point to approve this. TK, is that still your motion?
It is. Move it forward to the Board of County Commissioners for them to hold a public hearing.
And can you
Adopt
define
a
what we're
resolution
actually?
Adopt a resolution as recommended by the staff.
I don't have my agenda.
So I'll go through.
And the version that just came back to us from the county commissioner. I don't know what the date is.
The November 8th version, yes.
November 8th.
Yeah, I guess if you want to reference.
What's
that,
the
yes, that's right.
alternatives? We don't,
Say it again?
what's the alternative? Keep on doing this?
No, I mean, we could vote it down, we could vote no, and then they still do it. I mean, I don't know if, I don't legally, it doesn't start a clock. We have I don't know if the clock has started, I don't know if it starts a clock, there's a 30-day period.
The 30-day period started on November 21st.
Okay, so we're within the 30-day period of November 21st in order to take action. I guess if we vote, if we don't vote, what happens?
Take action. I mean, what are we gonna take action on? I mean,
Well, it's either recommending it as written, saying we don't like it, or maybe take no action. After the 30 days, it goes back to them anyway, is that correct? Can I ask, I mean, is that, I'm asking some legal
I
question.
think that's unreasonable. The statute talks that the PC approves, disapproves, or makes suggestions. If the PC chooses to make no action, well, then at some point, they're just choosing to make no action. I would recommend that, but if that's what the PC, that's what the PC.
Even if we disapprove it, there's no, the statute doesn't address what happens then, does it?
Statute says if the PC disapproves it, that in order to adopt it, the BOCC has to, this is nothing out of the ordinary, but the statute says this, has to have a majority of approval.
2 out of 3.
In this situation, we 2 out of 3, which is what they need anyway. I'm contemplating, I mean, I really don't know. I don't think of a factual situation where that wouldn't be the situation. Well, I suppose if you, well, yes, they need to.
So it's going
But that's
back.
what the
it's
statute
going
has
back
that
to when
language
we
in it.
approve it, disapprove it, or take no action.
And so Tate, to your question, there are,
Or make suggestions.
Or Or make suggestions, I hear you.
There's not been a second to the motion, but to state the motion. Well, I guess we need a second to restate it. Right? Is anyone seconding this motion?
So the motion is to follow staff suggestion.
Correct.
Yeah.
And be specific, that is the November 8th. Right. That's the only thing that's not in the staff recommendation.
That has their corrections on it as well.
Correct. Yes. That is their revisions of our recommendation.
Is that the red line draft?
Yeah.
I don't have.
This is not a red, oh, I'm sorry.
Are you including Victoria's stuff like you said, or is that in?
Well, I don't have an objection for the Victoria sending what her recommendations are to the Board of County Commissioners.
It may or may not already been done.
Well, if I may. What the November 8th version reflects. 2 years of work effectively. So the planning commission started, they put a certified copy to the Board of County Commissioners, Board of County Commissioners rejected it. But they took that red line that the planning commission had and started going through it for the past year. Then that was what was referred to your planning commission, which you've spent multiple meetings going over. You made recommendations to the board. All of the individual comments that were made by planning commissioners were sent with the ultimate recommendations. All the action items, all the planning commission minutes were sent to the Board of County Commissioners. Then on November 21st, after 2 additional work sessions going through all that, the board said, this is the version that we wanted. They've taken it all into account. This is the version that we want to put forward to the public. But the planning commission then needs to report within 30 days on that version. That's the November 8th version.
That's the one on the website that you can link. It says.
Right, and there's a red line of it. That red line reflects changes of the document against the 2021 land use code.
Currently in effect.
That's currently in effect.
And up there's the red line.
If you can scroll down, I don't think that's the November 8th red line.
So there wasn't a red line of the November 8th version. There's a red line of the original 2021 version. Correct.
Yes.
Correct.
Which is why I could not understand what the site.
That's when I clicked on, but there's no red line. I mean, I just clicked on the,
We got a link.
I don't see a red line.
To 507 pages.
Oh, mine's the
507 pages.
draft. It's 11/8.
I think it's.
The red line's not coming.
I've been looking long time.
So if we get back to,
Yeah, that is.
restate what Tom's proposal is.
Tom made a motion to recommend to the Board of County Commissioners to approve this version with 6 additional items. It's providing public notice to property owners currently zoned UGA because we're amending that map to no longer have UGA. Presumably, they will either make it Res 1 or 2.5 up to their discretion. They'll vacate resolution 2003 R27, which was street plans and 35+ acre subdivisions. We would vacate ordinance 2016-01 development application since pertinent aspects have been incorporated into the LUC. We'd update land use code fee schedule to reflect the LUC changes, and they would find resolution 2023 007 renewable energy moratorium is extinguished because now we have renewable energy in the new LUC. And the last one would be amending the intergovernmental agreements to reflect the LUC standards. So that would be all the actions they would take following a public hearing that they would hold.
Is there any room here in this proposal to say that we recommend that they eliminate the cistern paragraph?
We did that
Then we
already.
did that in the last one and they decided not to accept our recommendation.
Well, this is what we're doing. We're saying this, we agree with you, but we recommend that you take the cisterns out.
I can't vote.
That'd be an amended motion or a separate motion?
The motion on the floor does not have a second yet, so we're still not even discussing the motion yet. Does anyone else? Anyone else want to second the motion on the floor? If not, I'd entertain another
And
motion.
then we can amend it after that.
Or we just start with a new motion.
We're gonna start with a new motion. I don't have a second.
I mean, like.
Right.
I just have a question.
Yeah.
Are we gonna open up the public comment before we take a vote?
No, because the BOCC is holding a public hearing.
Your agenda notice this as a public hearing with public input.
Yes, and that was a staff. Whoops a daisy.
That was a mistake.
This is a work session. And that's why the BOCC spearheaded this whole thing, is because after the last denial of the last land use code and some of the threats that PC received, they wanted to take that burden over with public comment. Because at the end, as you've heard from our discussion, they are the ones that make the decisions. And so really telling us what you think, it'll help, you know, we've heard you, we've made suggestions to them. They're the decision makers, so.
Is it possible to take a vote at a work session? Doesn't it have to be a public hearing?
Actually, the way this was noticed is this is a regular meeting.
Okay.
And with a
So then we have.
posted with a posted agenda item.
Okay.
That's how it was posted. It also was posted as a public hearing, which it probably is not a public hearing, but this does look the way it's posted as a regular meeting with an agenda item.
Okay.
So looking at the posted agenda.
Are we required to take public comment during a public hearing? If we're saying this is a public hearing, because that's how it was posted, are we required to take public comment before voting? I mean, I know it's customary, but
Well, I would make a motion just out of the decency, all these people showed up from whoever, who knows where, to come speak tonight because it was posted, but it was gonna be public hearing.
Yep.
That we allow them the time to speak.
Sure.
I'd make that one.
And second,
Great, there's a motion and a second. All those in favor of opening the floor to public comment, please say aye. Any opposed, nay. Okay, so we will open this up to public comment. We'll keep it at 3 minutes. If we could get a chair, kind of in the middle in the hot seat. We didn't take any names down, so we'll just have you. What we'll do is we'll go around the room, and if you want to speak, come up. We'll give everybody 3 minutes. Yep. We're on. Yeah. Yep, please. Thank you. Okay, so again, this is now a public hearing. I'll just go around the room and ask folks, again, keep it 3 minutes, respect everyone else's time and our time. We'll be taking notes and, you know, this will go in public record to send to the BOCC. So starting at the left, gentlemen, would you like to speak? Yeah, Eli? Sure. You want to come up? Okay. You know,
Hi guys, I think I know most of you. I'm Eli Wolcott. I live in the Paonia area.
Can you state your address? Just for the record.
Stucker Mesa Road. Thanks for having me. I'll try to cover this in 3 minutes. I think that over the last 9 months, we've covered a lot of ground working together in a great partnership with the county commissioners and a lot of the staff here. I think we've addressed a lot of concerns that we've heard come forward from the community. I will go on to say, though, that I think that there are quite a few concerns that are as of yet unresolved. Some of them have been addressed along the way, but have not actually found their way into the code. And some of them are still kind of outstanding. I'm not sure that I can cover this in 3 minutes. I have them in writing for you guys that I can pass on. They're also online. I can forward them to all of you. I can probably highlight a few if it's useful, but I can kind of pass on what we've reviewed along the way.
Who is we in this country?
So I'm here representing myself, but also the Delta County Coalition. You can find us online, deltacountycoalition.org. Our comments are online there, and we've shared comments with staff, with some PC members, and with the Board of County Commissioners over the last 9 months. We have formed a civic partnership with the Board of County Commissioners, working together to try to address community concerns with the land use code. I can speak to a few of the issues that were brought forward tonight, and I'll try to keep this brief in 3 minutes. There's not much I can cover, but
There's outstanding concerns with things, mentioned earlier tonight, wells and springs. The section that was brought forward, we're hearing from a lot of people that it's not actually state statute, but that, there is a section number 4 in that list that limits people's use of springs and wells, on their own property, even if properly permitted. And that there are these very large, UGA areas, outside of the towns that were formed in the early aughts, the early 2000s, during the last housing boom, when the towns were really looking towards a much larger growth area that is probably not realistic. I think that it would be a great thing for that to be resolved prior to passing the land use code. Looking at what are realistic UGA areas and growth areas for the towns and meeting with the municipalities. Other things that we've covered, and again, I'll try to keep this as brief as possible. There's been some concerns about the current language in events and some conflicting information about what the event language would be. The current language about events is very restrictive compared to what the 2021 code states. And of course, events are a big economic driver for the county. I'll forward the details to all of you. There's a lot of concerns with the shift here to limited use instead of permitted use, especially in places where engineered studies are required. Apparently, most of these engineered studies start at about $5,000 or $6,000 a pop, and there's 7 or 8 of them that are potentially required. So there's a lot of concern in the community about those sort of costs. And the current 21 code allows qualified landowners and individuals, if they have qualifications, to do many of those, not all, but many of those studies themselves. The current draft proposes to remove that and require engineers to be brought in, which could get quite costly. It also interferes with the predictability. If you don't know if you might need 7 or 8 engineered studies before you get started on something, especially if it's simple, like a residence, it brings a lot of uncertainty into the equation.
Thank you. Would you send that to all of us? I know you had said that you talked to some PC members. It'd be nice if you sent it to staff and they could forward it to all of us.
Happy to forward on, and if anybody would like to see a copy tonight, happy to pass it around.
Thank you, Eli.
Thanks so much for having me here tonight. Appreciate it.
And if you could, please forward your civic partnership agreement with the county commissioners. I'd like to see that.
Sure, you can find out plenty more info on our
I've seen
website.
it, but I haven't.
Understood it. Thank you.
Normally represents much more people that is there.
I'm sorry?
Normal citizens represents much more people that is.
All right, Chair.
All right, gentlemen with the camera, are we speaking? We're just observing. Okay, ma'am in the hat, would you like to come forward and speak? Okay. No? You up front? Okay. We're gonna keep going around. Would you like to speak? Just state your name and address for the record, please.
Jennifer Kraft, Cedar Edge, 16425 Vermont Road.
Thank you.
I haven't had a chance to go over the new revisions on the land use code, but I have been to several of your meetings. The only suggestion that I have today is for your particular commission, not the commissioners. It's for you guys. From what I've observed, well, first of all, I've been on many boards, nonprofit, government, and sporting boards over the last 30 years. And you guys are lacking a piece that I think would save you a lot of time and a lot of frustration, and that is parliamentarian. Someone who understands how this back and forth works and keeps it from becoming this constant, you're not getting anything done. I've been on boards where things have not gotten done before. And that's the piece you're missing. A lawyer, unfortunately, is not a parliamentarian. It'd be someone completely non-partial who knows Robert's Rules of Order, you know, how you make a motion. I just saw you guys struggling to make a motion. It's so simple. Yes, we're going to approve this with these, you know, I'm sorry, Victoria's suggestions. But that has to be part of the motion, or they won't even consider Victoria's suggestions. So like it's very simple, it's procedural. And that's my suggestion for you guys is that if it's a volunteer position, I'm willing to volunteer to be a parliamentarian. I almost know Robert's rules backwards and forwards. And you wouldn't have to listen to the parliamentarian, but it'd be someone to refer to say, hey, I'm trying to make a motion. How do I do that? That person would say, this is how you state that. And then you move forward. And that's just a suggestion I have for you guys. I've seen a lot of struggling and a lot of, you waste a lot of time and I know you don't want to anymore. So.
If I can
that's my only
clarify,
suggestion. Yes.
I disagree. I didn't see Tom struggle at all to make a motion and you didn't get anybody to second it.
Okay.
Victoria didn't make a motion and so there was no opportunity to second. And so it was pretty cut and dry. There was a lot of discussion, which is typical of what happens. But I disagree.
Okay.
But thank you.
Anything else, Jennifer?
Thank you.
Thank you. Moving on down to the back. Any speaking? Okay.
Good evening, everybody. Thanks for coming. We always appreciate everything you do. I've had time to look at this. I've been at a lot of these meetings. Some of them are really.
Oh, yeah.
John, please state your name and your address, please.
Oh, sorry.
Yeah.
First name Charles, last name Cherek, Cherek. 5607 2000 Road Delta. I just thought I'd take a minute because sometimes you don't get to put any input in. You guys have a lot on your shoulders, making decisions about a million different things. Probably what is encompassed tonight, maybe 15, 20 items. But nobody ever gives you the opportunity to research things or the funds to go out and research things. So that, Paul, you put all this time in, there's no avenue for you to continue your education, if you will. So I would like to see somebody make a motion to the commissioners to start a fund so that if a real critical issue comes up, be it a cistern, be it a water well, be anything, that you could take a class, CMC or whatever you choose, and they'll throw some money into a fund so you can do this. I know you're busy. I know you guys put a lot of time into this. I put a lot of time in listening. But it's all part of the process, I guess. So that was the only thing I'd like to add. And there's never a time to be able to speak to you guys because you're always busy working on land use code, which I understand is really, really time consuming. Last but not least, I think as you go around maybe every hour or so, take a 5-minute break so that you can kind of reorganize your thoughts, use the restroom, get some water, instead of grinding it out in these chairs. Maybe we can have a fund for better chairs. Maybe that's all I got for you this evening. Thanks for your time.
Thanks, Jeff. Okay, we'll go to online. We'll start with Joshua Fry. And if you would like to speak, just let us know.
I'm good. Thank you so much for your time.
Thank you. Who's next?
Do you wanna speak up?
What is it?
Lucy Hunter.
Lucy Hunter, please. Okay.
Like Guy Fox.
How about this? If you're online and you would like to speak, raise your hand. It's gonna save us some mispronunciations. Okay,
Aaron Jared.
Aaron Jarrett. Please state your name and address, Aaron.
Hi, my name is, can you hear me? First of
Yes.
all, thank you. My name is Aaron Jared. I live in Hotchkiss, Hanson Mesa Road. I guess I just wanted to chime in. I was pretty involved in January, February last year with the process and came to a lot of meetings and hearings. And appreciate all the work and effort that has gone into really listening and working on this since then. It is a very complicated thing. I do, in my conversations, and I guess what I really want to put in there is there was a lot of issue in that round of community hearings in early 2023 of people not feeling like they were included or the voice of the people was somehow missing. And there's still that risk here going forward that I would really hope that both the Planning Commission and the Board of Commissioners would try and address, and not just post these things, but actively do some reach out to the community, because a lot of people kind of feel like, oh, it may be something we don't have to pay attention to, and don't want to land up in a situation where we have this big outrage again. It would be good to just design it well and, get clear and make it work for everybody as much as possible. I also want to put in that, I haven't had a chance to read through everything, but I have gone through the Delta County Coalition's websites, comments, and some of the writing and research that Eli and those people have put in. And based on that, I'm in agreement with a lot of their points and the things that still need to be addressed. And in talking to my extended family and community and friends, informally bringing these things up, I'd say I have a 15, 20, 30 people that are also in agreement with that. And so to say that my voice, it to some extent represents an extended group of people who don't have time or have family issues or can't make it or are technologically challenged, so they can't be in attendance. And I just want to say that it would be great if the county made sure that those voices were heard. Thank you.
Thank you, Aaron. Is there anyone else online that would like to speak? Please raise your hand at this time. Okay. Seeing none, we'll close the public hearing portion of this meeting. Thank you, commissioners, for affording the public to weigh in. I think it's needed, and even though it can feel like, again, we're not the end decision makers, it's good to hear from folks.
Clarification. We got a motion
There was
without a second.
Correct.
It was not considered.
Motion has died.
And where does that leave us with any recommendation or non-recommendation of county commission?
We're back to the table. We're back to the table. I would entertain any edits to the document or motions to approve or deny said document. Board of County Commissioners.
I would still like to see some language in there about the notification of the property owner. Specifically either service or certified mail. Wherever that section was that you addressed earlier about the mailings for relations, if we could add in the type of mailing. I would make a motion that
Make a note for staff to clarify the notification process.
in such a way that they'll be served properly rather than just a mailing. That will have, solid evidence that they were served violation.
How would it currently, if there was a notice of violation, what type of notice would that be?
I'm really tough. My past practice would be that it was certified mail when you get to a notice violation, but
Yeah,
we haven't done
right
that
now
yet.
we're making.
We haven't had to
notice-
yet.
Right now, we're making sure that notices of violation, which are the fifth letter, is it the fifth letter that goes out? That those are, made sure that they are properly served, to property owners.
Okay. So do you still want that motion?
Yeah, so the section that I'm looking at, and I don't know if this is the only section that mentions it, is I just have in chapter 13, section 4, D1. It's entitled non-compliance.
C1?
C1.
Oh, okay, D1.
Okay.
Yeah, section 4, I have D1, but it may be C1.
And you have language?
Yes, I would just like to make a motion that the language would read. If the violations are not resolved through voluntary compliance after 30 days, a notice of violation will be served upon the property owner. The notice of violation will indicate the violations present and a specific time, not less than 30 days for the violations to be resolved. If the violations are remedied, no further action is taken.
Motion on the floor. I know we can't see it. We'll have Victoria repeat it if there is a second. Is there a second Victoria's motion? Hearing none, motion dies. Are there any other motions regarding edits or moving this on to the Board of County Commissioners?
If nobody else has a motion about it's our process of moving it forward to the county commissioners, I would make one. But it would be a different one. It would be one that says essentially, we have given you our best thoughts on at least 2 occasions of which you rejected most of them. And so, and we had our meeting tonight and we had our meeting several weeks ago where we did similar things of presenting our views. So you pretty much have everything we have, and good luck, do what you want. And we'll have to enforce the thing when you finally pass it.
Could you read that motion again?
What do you have to do? What do you have?
It's essentially comment where the process is. I don't hear any huge interest in approving it or disproving it, frankly. And so that's what I'm trying to capture is.
So if I may, you're effectively suggesting a motion to recommend moving it forward with no recommendation, no further recommendations, maybe put it that way.
Which is what TK's motion was prior.
I elaborated a little bit. You made a little bit.
There's a motion. Is there a second?
Did Hardy have a question?
Yeah.
Is the motion?
I was still going here.
Okay.
On that little list you got going on there, those things, that's going, what's happening with that?
This is staff's recommendation. So if, again, Steve's very elaborate motion goes, it's providing public notice to UGA members, vacating a couple resolutions, updating fee schedules, and finding renewable energy moratorium is no longer, and amending the IGAs.
So we've added to that,
We've added nothing to that.
so we're not adding nothing to that.
I've not heard anything.
Well, I mean, I don't wanna beat a dead horse here, but in the process of
But
redoing.
before you do, there's still a motion on the floor. Is there not a second?
What is the motion for? Yeah, you were, I mean.
To recommend your motion earlier, just in not so many words.
To the Board of Commissioners. Was his motion just put it on with no comment?
I'm still unclear. Are we, my original motion was to move to approve, and there was no second, so it died.
Correct.
It sounds like Steve was not
Or
necessarily
neutral.
using the language approved. It's like moving it on with no.
No approval or disapproval. just
Yeah.
Again, there is not an approval or disapproval. We are either recommending or not recommending.
So you wouldn't wanna do that if you're.
Yeah, I didn't hear any position of anybody about recommending or not recommending.
You're saying you don't have to.
So you don't have a motion. You just.
No, it's moving it on effectively, without comment on approval or disapproval.
I think what you mean parliamentarian.
Well, that's the other option we had. I mean, John talked about that.
Your motion would be to do nothing. And good luck.
It's the communication back to them about
2 years enough.
no decision on approval or disapproval.
Do you have any thoughts or within your motion, are you including these staff recommendations about vacating the certain resolutions and?
Oh,
giving
or-
notice?
Well,
I mean, we have
I
the,
don't know that there are things that the BOCC wouldn't do anyways, but I
wanted to add it though. I mean, that was where I was getting.
well, if you want to second his motion, you could happily try to amend his
Well,
motion.
if it's, I guess, involved in that. I guess I'll second his motion. We'll go to vote.
No, I haven't heard a second, so.
I'm just saying.
Already second, great.
Is the motion make no recommendation of approval or denial, just. That's what I'm asking, not clear.
Approving it or.
Sorry, what the motion is. I heard Carl speak about it, and I didn't hear Steve.
I agree to that. I think we have no compelling comments about approval or disapproval. Which means that we say nothing or we communicate a no comment. And that's my motion.
It's no comment.
Yes, we have.
Alrighty,
I don't know if this should be under this, but. When they do go to the intergovernmental agreements to, in the next stage of this deal, to include. The zones of the water districts, being looked at. Not just the municipalities, but the water districts. To look at their actual zones versus their actual, areas they can supply right now today. Not their 2045 area, but their, area right now.
That's an amendment to the motion then.
And there might be another one, I don't know.
okay. Already moves to amend the motion to include comment around looking at water districts, special and private. Okay, is there a second to that amendment?
I would second that. And I also would like to add an amendment that they look
Wait.
at.
First amendment. Any other discussion around this first amendment?
I don't know what you're asking the Board of County Commissioners. Are you asking them to look at every water company or every water district?
How many are, you act like there's like a 900.
There's a lot.
There's a lot.
There's a lot.
There's a couple hundred.
Well,
And if you're asking them to look at everyone and to get them to determine where they can serve today versus where they're projecting to serve,
Yes.
I think I'm not saying that it's not a reasonable ask. I don't know that you're gonna get it as.
I don't know if I'm gonna get it either, but if we're gonna go into looking at the intergovernmental agreements. This is one of the biggest things affecting growth in Delta County, other than the municipalities. I don't think it's so much the municipalities. I think it's the water district deal with it. And it's stunning the growth of Delta County. But I think it is worth looking at.
If I may, the staff recommendation is to amend the intergovernmental agreements to reflect the changes of the LUC, for example, water supply. So it seems as though staff and probably the BOCC already has at the top of their mind in looking at these IGAs, water.
There you go, because I've been.
So I think that's kind of already on the agenda.
Go with that.
Okay,
So the motion on the floor is to add comment regarding water.
Well, if she's saying that they're already, gonna look at that, I guess I don't even.
Then are you withdrawing your motion?
Yes, I better.
Okay.
I didn't know that was in there.
So we're back to the original motion.
There's still the motion,
There's
Steve's
still the
motion.
motion to make no recommendation. Because
Yeah, I don't want my motion to be
Yeah,
Um,
I wouldn't.
a killer here in anybody's notion of what we should do. If somebody has a motion they would rather make about approval or disapproval, which I've not heard, except Tom's didn't go anywhere, then please make it and I'll withdraw mine. I mean, if there's a disapproval motion, I would withdraw mine and we can consider that. I'm just trying to move things forward tonight so we can go home, frankly.
until we resolve this motion.
Yeah.
Because we have a motion and a second. And we're now have potential amendment of that motion. Then we can go, we can decide. We can vote it down or down.
Maybe we should
You're
vote
saying
on
you
it.
don't want to amend?
No.
Okay, I'm sorry, I want to make sure.
So just for their purposes.
Steve, would you restate your motion that we will vote on following the restate?
My motion is that we pass communication to the county commissioners that we have taken no position on approval or disapproval of the November 8th draft land use code.
And in regard to the 6 items of recommendation.
Yeah, I would say I would include the approval of those. If that's deemed necessary. I mean, I don't have one opinion one way or the other, but if it helps to have them approved with that recommendation, that would be okay.
So what would you like?
That would be my motion, that we approve those. We're not making any approval, disapproval decision.
Including the 6 action items of vacating, updating and finding.
To include the following 6 recommendations.
Yeah,
Okay,
7, actually. Strike the cistern paragraph.
Yeah, I'm with that, yeah.
that is not included in Steve's motion. Someone would like to make an amendment to Steve's motion.
I'll make a motion to amend Steve's amendment of returning the November 8th document to the county commissioners with no approval or disapproval to include the following 6 items in addition to striking the cistern paragraph.
Okay, a motion, is there a second to essentially,
So you're second to the amendment, so we've already done that, maybe backups. You're saying, let's throw it back up.
That tells them how serious we are.
we're telling them.
Let me just ask, because I asked before. Should we be eliminating the language regarding hauled water and leave cisterns? Because that's what you're really
That's
addressing.
really the issue.
I know, I want to make sure I get across, because I thought if we've already gone through the removing the cistern language, and they put it back in. But we haven't gone through removing the whole water issue, and maybe we just make that recommendation. I'm not looking to change your amendment, I'm just saying I want to clarify.
Can haul water.
Yeah,
If we strike that paragraph.
yeah.
Keep the rest of the paragraph, you have to have the can hold water. I mean, it goes together.
Less is more, I think.
let me remind us, we're piggybacking this on a motion that says we don't care.
We're sitting on the fence.
So why are we doing it? We know, they know we're frustrated, they're frustrated, we're all frustrated. I'm frustrated.
Well, then, introduce about approving or disapproving.
We have an amendment on the floor. We have a motion to amend regarding water. PK brought up something regarding different language of the water.
During the discussion, because we had a second. This
So should we take a vote?
yes. Yeah, does Matt want to clarify his amendment?
What is your amendment?
The amendment is to strike the whole paragraph on cisterns, which would also strike any verbiage to hauling water. There you go. Being prohibited.
I'll second that.
Okay, when the discussion will speak.
Should we see it? No, Randy says no.
You can't strike cisterns, you can strike cold water, but many wells don't put out enough gallons per minute. And they have to rely on a cistern.
That's.
He's saying that he wants them to be able to have a cistern.
Okay.
We just have no mention of cisterns.
Regulating cisterns.
You need a section.
Now that it's been clarified, is there any other discussion on the amendment to strike the paragraph? Restricting cisterns.
Just to be clear, one more time. We're striking this section on, so there'll be no reference to cisterns. And the language regarding hauled water stays in.
No. the whole
No.
thing.
That's all, that's all.
Everything.
That's all part.
Okay,
That's all part.
So that would effectively make hauled water permissible
and cisterns.
and cisterns, any type of hauled water or cisterns permissible for anyone in the county.
Thank you for clarifying.
Bring back the old days.
Okay,
So effectively, you're recommending approval with the recommendation to remove chapter 5, section 3B3. That's effectively what you would be doing,
And those 6 items.
and the additional 6.
so
There's no comment.
a vote to approve this
I
amendment.
think that's ambiguous.
Sure is.
That's not what he's saying.
Was that?
He's not saying approve.
No.
You're saying not approval, but we believe they're.
I'm not saying not returning it.
Telling you.
So
Yeah, we're voting on striking, we're voting on striking the cistern language. We're gonna do a, raise your hands, all those in favor, raise your hands to strike the language.
See you later.
So we're not voting on the general motion.
No, it's just cistern. So I have 1, 2, 3, and 4. All those opposed to that, please raise your hand. 1, 2, 3, 4. David has abstained. Thank you, David. Just split vote.
I can't vote. I can't vote.
Failed.
Does it fit?
It's 4-4.
Failed.
I think that's fair on the splits.
More parliamentarian questions. And David not vote.
Yeah, John even thought it in bed, you know.
So this is the motion that I seconded it.
Yeah, you sure did, Art. You can rescind it.
I'll rescind it.
Oh, great. Okay.
It failed, but.
I mean, you take motion, but that's sitting.
No, he just rescinded his second.
Okay. Okay, I'm gonna make a motion. Jim can move this along. I make a meeting that we do not approve.
Hey, wait,
Land use.
conversation here, I can't.
Land use code as presented.
Motion on the floor from Tate is to not recommend. There's a second from Victoria.
We have a motion that we haven't voted.
He rescinded his second.
He rescinded his stuff, excuse me.
He rescinded his second, excuse me.
Parliamentary.
We voted, and that amendment was voted as a 4-4 tie.
So that vote was voted down. Hardy withdrew his second to my motion. That means we're back.
Floor is open. Tate
Unless the well thing.
moved to deny.
Okay,
Only because he rescinded his second and the motion says no second.
it wasn't clear that he
Yeah,
rescinded the original motion, I'm sorry.
And now we have not seconded a move to approve. We've seconded and rescinded a move to do nothing. Now there is a motion and a second to deny
Can't we-
recommendation.
And here's the, it was seconded, correct?
Victoria second.
And I'll just say that doesn't seem to be a large, people that want to recommend approval, so I'll recommend the other. I don't personally approve, but wasn't gonna throw sin in the sandbox. And so I'm just gonna recommend non-approval to get on record and, move this along.
Any other discussion?
That means when you recommended essentially denial, you're not including any of the 6 issues regarding staff's recommendation. Nothing gets moved forward.
Correct.
I'm making no recommendation for approval for anything.
Okay. We need a second, right?
Victoria has second. We are in discussion.
I did second that, but I'd like to make an amendment that we recommend approval for the 6 agenda items.
But denying the whole thing.
They wouldn't work.
I deny you're right,
Yeah.
Yeah.
Because they wouldn't go through.
What my thought process is they should look at the IGAs, the UGAs and water supply before we vote on this.
In theory, if we deny it, they would presumably look at those things if they
Or
were
to just say, here, we voted for anyway, so.
You know, I think Steve had a great point, we battered this thing around long enough. And they put their language forth what they want. Let them have what they want, they're the elected officials.
Yeah, and then make a motion. If this vote fails, then you should make a motion to approve. Which would be fine.
Which is where I was going for with you before, but it didn't get a second.
Is there any more discussion around?
We didn't get a second, so we've gone around.
What?
We're going to take a second.
We're still in discussion.
Hamstrung really, because, yeah, we've made our recommendations, they don't want them. For the most part, they don't want them, they just what they wanted. And I think a denial or a non-approval is our way of saying, we don't feel like you took our recommendations into account. You're gonna do what you wanna do, but we don't, on a whole, we don't recommend, or we don't approve of the changes you've made to our recommendations. And so I think that is the statement, Steve wanting to make a statement to them saying we don't really have a choice here. Voting to not approve this is our way of making that statement.
Can I comment on it? That's why I made my motion. I thought a motion to deny would be would be seen as a political sentiment by many in the Delta County community. I didn't want it to be seen as that, because I don't think it is. I think it's a frustration perhaps, but it's not a political comment from the planning commission. That's my caution to you all.
So
With a negative vote.
when I made the motion, let me just explain, I can't support it because I think the most definitive part of the document is how you define where you can operate your land use, which is table 2B. And I don't think there's consistency there, and I think it shuts out the public, the affected people. So that's why I can't personally support it. The rest of it, fine. I'm over at this point, but I can't support it, so I made the motion.
Yeah.
And we got any other discussion already?
So I don't often defend BOCC, this, they are their own group and they do what they want. They have adopted a lot of our language, just not specific things like 2B, which we knew was a push. They made some changes to the subdivision. We didn't think, I guess my interpretation is they changed the language so you do not need to have a minimum 35, 20, or 5 if you subdivide. Is that correct? They took that
Well,
language out.
what they took out was, in order to request the variance of lot size, it would only be allowed in the A35 or A20 zone. They took that out. So you request the variance of lot size in any zoning designation.
Okay, so you can subdivide, not be required to have you can take a 35. If you had 40 acres, you could subdivide it into two 20s and still say, or 25 and 15. You're not required to leave a 30.
As long as you get a variance.
Okay, variance, okay. So they made recommendations and they did adopt those. Some of the primary ones, which we spent a lot of time on, we had a lot of conversation, they didn't adopt. I guess that's my way of saying, I don't want to support a motion that's a protest.
We'll vote that way.
Yeah.
Well, I will vote, and that's what this discussion group is. I won't support it because I feel like it'll be a protest. And I just don't want to. It is their document. They took it away from us when they rescinded the first one. They made us go through it and give recommendations. They adopted some, and now some of the critical things. You heard me tonight about zoning. I don't think they've addressed that issue. I think we're, that's an issue that I think is still there. But I don't want to protest it. Yeah. So I wouldn't support a denial. That's all.
I agree. I made the motion. For me, it's not political. I could care less. It's just the inconsistencies that really affect people's lives and it alter how they would be able to use documents.
And I'm not
It's not
saying
finished.
And I'm not saying you're not true. I'm just saying the vote represents something else beyond that.
Okay, make sure, let's write down which way you vote then. Do you feel that way?
Is there any other discussion around the motion?
Yes.
Yeah.
Tate, in your mind, do those 6 items, if they are included, address the issues you're concerned about?
No, and I don't think you can vote for to non-approval and then vote for those 6 issues because there's inconsistency there too. Personally, and I'd be happy if you all vote against my motion because we can leave, but.
If we vote against you.
And staff recommendation, priority over the planning commission too. I mean, there's 6 bills there.
Well, 6 deals, if it is recommended to approve, then we would have to follow those 6 steps. If it is recommended not to approve, they wouldn't do any of those
There
things.
you go. Vote.
We would keep the 21 code. All those in favor of Tate's motion of recommending denial of the Board of County Commissioners November 8th draft of the LUC?
Can we do a roll call vote?
Yes. How is roll call vote done? Just
Yeah,
case by case?
yeah,
Okay.
nay.
No, we've been on this way the whole day. TK.
Disapproved.
That's the statutory.
I would like to-
Okay, recommend for disapproval, starting with Tate,
Starting with you.
I recommend for disapproval, yay.
yay.
Hey, why are we changing this up? We've been running this way the whole way.
Keep it fresh, Victoria,
Yay.
Matt. Cardi,
Yay.
You're not- you're not voting. Steve,
I think I'm gonna vote yes.
I've already stated that I'll vote nay.
Way to stand up, Steve.
I think I'll vote yay.
okay,
Yes.
that passes 5-3.
You have to vote.
Nope.
I grew up there.
Who's the
We need to
third?
vote on that.
And who the third?
Who's the third day?
Who's the third?
5-3 pass.
5-2.
5-2.
5-2, I'm sorry.
Yeah, make sure that's right. Yeah, there's only two of us.
Tom's in the good graces again.
Okay, 5-2.
Boy.
Okay,
Think I'm kissing.
back to the agenda. That was our public hearing item. Is there a department report? Great. Commissioner comments, requests, and referrals. I think we've commented enough tonight.
We have no meeting next. In the next, we do not meet till January, correct?
January 10th. Do we have anything tentative on the agenda?
Is there agenda items?
Okay. Keep it as a placeholder. If there's nothing that comes up, we won't meet. Okay, we are adjourned.